Copyright infringement is the use of works protected by copyright law without permission, infringing certain exclusive rights granted to the copyright holder, such as the right to reproduce, distribute, display or perform the protected work, or to make derivative works. The copyright holder is typically the work's creator, or a publisher or other business to whom copyright has been assigned. Copyright holders routinely invoke legal and technological measures to prevent and penalize copyright infringement. Copyright infringement disputes are usually resolved through direct negotiation, a notice and takedown process, or litigation in civil court. Egregious or large-scale commercial infringement, especially when it involves counterfeiting, is sometimes prosecuted via the criminal justice system. Shifting public expectations, advances in digital technology, and the increasing reach of the Internet have led to such widespread, anonymous infringement that copyright-dependent industries now focus less on pursuing individuals who seek and share copyright-protected content online, and more on expanding copyright law to recognize and penalize, as indirect infringers, the service providers and software distributors which are said to facilitate and encourage individual acts of infringement by others. Estimates of the actual economic impact of copyright infringement vary widely and depend on many factors. Nevertheless, copyright holders, industry representatives, and legislators have long characterized copyright infringement as piracy or theft, language which some U.S. courts now regard as pejorative or otherwise contentious terminology. The terms piracy and theft are often associated with copyright infringement. The original meaning of piracy is robbery or illegal violence at sea, but the term has been in use for centuries as a synonym for acts of copyright infringement. Theft, meanwhile, emphasizes the potential commercial harm of infringement to copyright holders. However, copyright is a type of intellectual property, an area of law distinct from that which covers robbery or theft, offenses related only to tangible property. Not all copyright infringement results in commercial loss, and the U.S. Supreme Court ruled in 1985 that infringement does not easily equate with theft. Piracy, the practice of labeling the infringement of exclusive rights in creative works as piracy, predates statutory copyright law. Prior to the Statute of Anne in 1710, the Stationers' Company of London in 1557 received a royal charter giving the company a monopoly on publication and tasking it with enforcing the charter. Those who violated the charter were labeled pirates as early as 1603. The term piracy has been used to refer to the unauthorized copying, distribution and selling of works in copyright. Article 12 of the 1886 Berne Convention for the Protection of Literary and Artistic Works uses the term piracy in relation to copyright infringement, stating, pirated works may be seized on importation into those countries of the Union where the original work enjoys legal protection. Article 61 of the 1994 Agreement on Trade-Related Aspects of Intellectual Property Rights requires criminal procedures and penalties in cases of willful trademark counterfeiting or copyright piracy on a commercial scale. Piracy traditionally refers to acts of copyright infringement intentionally committed for financial gain, though more recently, copyright holders have described online copyright infringement, particularly in relation to peer-to-peer file-sharing networks, as piracy. Richard Stallman and the New Project have criticized the use of the word piracy in these situations, saying that publishers use the word to refer to copying they don't approve of, and that they, publishers, imply that it is ethically equivalent to attacking ships on the high seas, kidnapping and murdering the people on them. Theft. Copyright holders frequently refer to copyright infringement as theft. In copyright law, infringement does not refer to theft of physical objects that take away the owner's possession, but an instance where a person exercises one of the exclusive rights of the copyright holder without authorization. Courts have distinguished between copyright infringement and theft. For instance, the United States Supreme Court held in Dowling v. United States that bootleg phonorecords did not constitute stolen property. Instead, interference with copyright does not easily equate with theft, conversion, or fraud. The Copyright Act even employs a separate term of art to define one who misappropriates a copyright. An infringer of the copyright. The court said that in the case of copyright infringement, the province guaranteed to the copyright holder by copyright law, certain exclusive rights, is invaded, but no control, physical or otherwise, is taken over the copyright, nor is the copyright holder wholly deprived of using the copyrighted work or exercising the exclusive rights held. Motivation. Some of the motives for engaging in copyright infringement are the following: pricing, unwillingness or inability to pay the price requested by the legitimate sellers. Unavailability, no legitimate sellers providing the product in the country of the end user, not yet launched there, already withdrawn from sales, never to be sold there. Geographical restrictions on online distribution and international shipping. Usefulness, the legitimate products comes with various means of restricting legitimate use or comes with annoying non-skippable advertisements and anti-piracy disclaimers, which are removed in the pirated product, making it more desirable for the end user. Shopping experience, no legitimate sellers providing the product with the required quality through online distribution and through a shopping system, with the required level of user-friendliness. Anonymity, downloading works does not require identification, whereas downloads directly from the website of the copyright owner often require a valid email address and/or other credentials. Sometimes only partial compliance with license agreements is the cause. For example, in 2013, the U.S. Army settled a lawsuit with Texas-based company Attribution, which makes software that allows the Army to track their soldiers in real time. In 2004, the U.S. Army paid $4.5 million for a license of 500 users. While allegedly installing the software for more than 9,000 users, the case was settled for $50 million. Major anti-piracy organizations, like the BSA, conduct software licensing audits regularly to ensure full compliance. Kara Kusumino, director of the Tribeca Film Festival, stated in April 2014, "Piracy is less about people not wanting to pay and more about just wanting the immediacy. People saying, 'I want to watch Spider-Man right now,' and downloading it." The statement occurred during the third year that the festival used the internet to present its content, while it was the first year that it featured a showcase of content producers who work exclusively online. Kusumino further explained that downloading behavior is not merely conducted by people who merely want to obtain content for free. "I think that if companies were willing to put that material out there, moving forward, consumers will follow. It's just that they, consumers, want to consume films online and they're ready to consume films that way, and we're not necessarily offering them in that way. So it's the distribution models that need to catch up. People will pay for the content." In response to Kusumino's perspective, Screen Producers Australia Executive Director Matt Dina clarified the motivation of the film industry. Distributors are usually wanting to encourage cinema-going as part of this process, monetizing through returns, and restrict the immediate access to online so as to encourage the maximum number of people to go to the cinemas. Dina further explained the matter in terms of the Australian film industry, stating, "There are currently restrictions on quantities of tax support that a film can receive unless the film has a traditional cinema release." In a study published in the Journal of Behavioral and Experimental Economics, and reported on in early May 2014, researchers from the University of Portsmouth in the UK discussed findings from examining the illegal downloading behaviour of 6,000 Finnish people, aged 7 to 84. The list of reasons for downloading given by the study respondents included money saving, the ability to access material not on general release, or before it was released, and assisting artists to avoid involvement with record companies and movie studios. In a public talk between Bill Gates, Warren Buffett, and Brent Schlender at the University of Washington in 1998, Bill Gates commented on piracy as a means to an end, whereby people who use Microsoft's software illegally will eventually pay for it out of familiarity. As the country's economy develops and legitimate products become more affordable to businesses and consumers. Although about 3 million computers get sold every year in China, people don't pay for the software. Someday they will, though. And as long as they're going to steal it, we want them to steal ours. They'll get sort of addicted, and then we'll somehow figure out how to collect sometime in the next decade. Developing world in media piracy in emerging economies, the first independent international comparative study of media piracy with center on Brazil, India, Russia, South Africa, Mexico, Turkey and Bolivia. High prices for media goods, low incomes, and cheap digital technologies are the chief factors that lead to the global spread of media piracy, especially in emerging markets. According to the same study, even though digital piracy inflicts additional costs on the production side of media, it also offers the main access to media goods in developing countries. The strong trade-offs that favor using digital piracy in developing economies dictate the current neglected law enforcements toward digital piracy. In China, the issue of digital piracy is not merely legal, but social, originating from the high demand for cheap and affordable pirated goods as well as the governmental connections of the businesses which produce such goods. Motivations due to censorship. There have been instances where a country's government bans a movie, resulting in the spread of pirated videos and DVDs. Romanian-born documentary maker Ilinca Caligarianu wrote a New York Times article telling the story of Irina Margarita Nistor, a narrator for state TV under Nicolae Ceausescu's regime. A visitor from the West gave her bootlegged copies of American movies, which she dubbed for secret viewings through Romania. According to the article, she dubbed more than 3,000 movies and became the country's second most famous voice after Ceausescu, even though no one knew her name until many years later.